Harold Koh, as you know, is the former dean of Yale Law School, obviously a brilliant lawyer, and but now he's been confirmed as the legal advisor to the State Department. Of course, many people saw Professor Koh, Dean Koh, as likely on a pathway to the federal judiciary at some point, including the United States Supreme Court. But in the role he plays now, as the legal advisor of the State Department, he, of course, is the one who gives the legal advice to the State Department with regard to the debacle in Honduras now, about who is actually the president of that country. And, of course, the State Department has declined to release his legal advice while the debacle continues. But he has a very important role because, of course, he will provide advice to not only the State Department, but to the Department of Defense and other federal agencies that are very important. Well, to the point that I wanted to make about Dean Koh, he has said that federal judges should use cases and controversies before them to what he says, quote, vertically enforce or domesticate American laws with international norms and foreign law. He's argued that federal judges should help, quote, build the bridge between the international and domestic law through interpretive techniques. And he said he believes in what he calls transnational jurisprudence. This philosophy, according to Evan Thomas and Stuart Taylor in Newsweek, they said could, quote, erode American democracy and sovereignty if taken to its logical extreme. In June of this year, 62 senators voted to confirm Harold Koh to the State Department. And then there's Don Johnson. Don Johnson has not been confirmed, thank goodness, to the Office of Legal Counsel at the Department of Justice. This, of course, is a position of tremendous influence in the federal government. It's sometimes been called the President's Law Firm. This is the office that provides legal advice to not only the Department of Justice, but to the entire executive branch, and whose opinions are considered to be virtually the final word, absent a court ruling on the matters upon which they opine. Of course, there have been a distinguished lineage of people who have been chief of that office, including William Rehnquist, including Justice Scalia. And as we know from the recent, over the last 8 years or so, debate about things ranging from rendition to enhanced interrogation techniques and the like, this office is very important in determining the scope of authority of the Central Intelligence Agency or intelligence community at large, and of course other federal agencies. Ms. Johnson is currently working as a law professor at Indiana University, and I think it's fair to say that she harbors what only can be described as radical views. On national security, she's taken a very narrow view of executive power and a very expansive view of the rights of terrorists. She said that she once celebrated the 4th of July by closely rereading Lawrence versus Texas, which she said represented her vision of America and where we should be heading. She's called originalism, as applied by Justice Scalia, a lie. She said it has the effect of freezing constitutional meaning at a time when only white propertied men were fully protected under the law. Well, Ms. Johnson's views are so radical that not even some of our friends on the other side of the aisle can vote to confirm her, and so she has not been confirmed by the Senate, and the threat of a bipartisan filibuster of her nomination has caused her to remain in the private sector at Indiana Law School, where I think she ought to stay for some time. And then, of course, there is Judge Sotomayor. Now, I have to tell you, Judge Sotomayor is a charming person with an incredible life story, and someone that is easy to like and admire. Her career is the embodiment of the American dream, as we've heard over and over again. And she's had a lot of judicial experience as a district judge and as a member of the Court of Appeals. But based on a careful review of her decisions as a federal district court judge and a circuit court judge, I found most of them to be what I would consider to be within the mainstream. But of course, the role of a Supreme Court justice is much different from that of a lower court judge who knows that her decisions will be reviewed by a higher court. But in this case, it wasn't so much what the judge had decided as a judge, it was what she had said in various speeches and seminars that caused us to wonder, will the real Sonia Sotomayor please stand up? For example, she said there's no neutrality in the law. Other times she said that the role of judges is to make policy. You remember that YouTube video clip where then she said, well, she realized she was on film and began to backtrack immediately to sort of knowing laughter in the crowd. She said that foreign law can help judges get their creative juices flowing as they interpret the U.S. Constitution. And she said that a judge's ethnicity and gender should influence a judge's decision, and that judges with a particular background actually make better decisions. And you'll remember the quote I'm thinking about. And so, in the end, I did not feel like I knew what we were getting in the Judge Sotomayor in her case, and I could not support her nomination. And I'm going to talk a little bit more about that hearing and other things that I think sort of gave us foreshadowing of what future Supreme Court confirmation hearings will be like. So in a short time, we've seen some nominees, some confirmed, some not, that I think tend to show the Obama administration's clear determination to advance what I think is a philosophy of activism, and in the case of judges, judicial activism. But, you know, it's the most remarkable thing about it, and this is particularly so in the Sotomayor confirmation hearing, is that she refused to embrace, indeed she seemed to repudiate some of her more radical statements that I quoted that she made in various speeches and seminars and in her other written materials. And we've seen a refusal to try to defend a philosophy that might support judicial activism on the merits. Now, I found it very surprising, and I must say it's also, I found it encouraging to hear that the proponents of judges who might otherwise embrace judicial activism, that philosophy, refusing to defend it, but indeed they use the words of those of us who believe in judicial restraint to get through the confirmation hearing. I had expected, with 60 votes in the U.S. Senate and with a president who shared the philosophy of judicial activists, that they might make a public case for it at Supreme Court confirmation hearings. They might have claimed a mandate, perhaps, for the kind of judge that candidate Obama said he would want if he were confirmed. And they might have used the confirmation hearings to make a case to the American people that the philosophy of judicial restraint is wrong and that theirs is right. But I think very noticeably they refused to do that. Instead, they did two interesting things. First, they pretended to be champions of judicial restraint. Judge Sotomayor, you may have heard, she said, we asked what is her judicial philosophy? She said, fidelity to the law. She said that judges should rely upon the original intent of the framers in interpreting the Constitution. She said the intent of the founders was set forth in the Constitution. It's their words that are the most important aspect of judging. You follow what they say in their words and you apply it to the facts you're looking at. Pretty unremarkable to those of us who believe in judicial restraint. Very remarkable, coming from somebody who said there's no such thing as neutrality in the law. Actually, what she said at their confirmation hearing sounds like something we'd hear at a Federalist Society meeting like this, right? On the issue of foreign law, notwithstanding her previous statements that said that judges should consult foreign law to get their creative juices flowing when interpreting the U.S. Constitution, at her hearing she said foreign law cannot be used as a holding or a precedent or to bind or influence the Constitution, influence the outcome of a legal decision in interpreting the Constitution or American law.